let me welcome the audience to the sixth and final in a series of webinars organized by the European branch of the Chartered Institute of Arbitrators on how different national laws regulate certain fundamental issues in arbitration. The previous webinars covered corporate law, arbitrability, the party arbitrator relation, oral hearing practice, interim measures. This one deals with the recognition and enforcement of foreign arbitral awards. And these webinars are recorded and will remain available on the CIARB platforms. In this webinar, we will compare approaches in France, Germany, Greece, Lithuania, Italy, Russia, and Spain. And again, like the other seminar I moderated last November on arbitrability, this is intended to be a guide rather than an interactive discussion. Therefore, time for questions will be limited, but we may discuss a few at the end of the presentations. And you are invited to submit your questions in the Q&A section. If some questions cannot be answered, I can tell you that the speakers will be more than happy to receive questions through direct contact with them. Each of the distinguished speakers will report on the approach taken in their state. And I will briefly introduce the speakers before giving them the floor, while you may find additional information about them in the biographies that I have already posted in the chat room, and I hope that you can see it. Otherwise, I can send the biographies via email after this webinar. Now, in the context of the recognition and enforcement of a foreign arbitral award, it is important to consider that despite the New York Convention establishes uniform principles, there might be procedural peculiarities when the judicial system of a particular country is approached for the recognition of the foreign award or for the recognition and enforcement. And here I would like to quote Redfern and Hunter, in particular a paragraph on this very subject, which is entitled The Need for Local Advice. And they write, when national courts are asked to recognize and enforce a foreign arbitral award, they are usually being asked, in effect, to apply the provisions of international conventions. Nevertheless, they will do so in their own way. This is well established. The New York Convention, which lays down the conditions under which awards are to be recognized and enforced by contracting states, leaves the rules of procedure to the determination of each contracting state. In consequence, before embarking upon proceedings for recognition and enforcement of an international award, it is essential to consult lawyers experienced in the arbitration law of the forum state. End of quote. It is therefore useful to have at least an idea on how the different states approach this issue And we will clarify this by putting the same questions to each speaker. And the question are, number one, how your national law regulates recognition and enforcement of foreign arbitral awards. Question two, is the content of the national law on recognition and enforcement fully consistent with the New York Convention? And if not, which are the main differences between the convention and the national law? Question three, is the decision that upholds or dismisses the recognition subject to challenge? Sorry. Question four, are there taxes, court fees, stamp duties to obtain the recognition and enforcement? Question number five, if we will have enough time, is there a particular circumstance that you believe applicants should be aware of when they seek recognition of the award in your country? So now we start with the questions to our distinguished speakers, and we start with France, and Alexandre Malan will present the legal frame in France. Alexandre is a fellow of the Chartered Institute of Arbitrators and attorney at the Paris Bar in the law firm Belot, Malan et Associés, where he is a senior partner. His focus is on arbitration and international litigation. So, Alexandre, over to you for the French perspective.
Thank you very much, Jacopo. In a few words, maybe I will not be long, but just to describe the French context. So we have a set of dispositions which are in a code, which is the French Code de Procédure Civile, the procedural code, which contains basically all applicable procedural rules for civil, commercial proceedings, and there is a set of dispositions for domestic and international arbitration. So this set of articles are in Article 1487 and sec of the code, and it's quite complete. But it's very important to understand that there is a very important corpus of case law in France, and the Court of Appeal of Paris, which has jurisdiction to decide on recognition and enforcement and annulment proceedings against international arbitration awards, has a very long and in-depth tradition of interpretation of those articles, and it's a very important set of case law, as well, of course, of the decisions of the Cour de Cassation, the Supreme Court. So we will discuss about that later on, but that's basically the French context.
Thank you, Alexandre. Now we go to Germany with Dr. Axel Rigg. Axel is founder of Rigg Rechtsanwälte, a German niche law firm active in cross-border arbitration and litigation. Axel is admitted to the bars in Germany and Spain. He is a past chair of this branch, the European branch, past member of the CIARB Board of Trustees from 2013 to 2020, and he's a member of the Chartered Institute of Arbitrators. Axel, which is the situation in Germany?
Jacopo, thank you very much. It's a pleasure to participate in this webinar, and I can be very brief. The situation in Germany is similar to the situation in France. The law regarding arbitral procedure is embedded in the Civil Procedure Code, in the Zivilprozessordnung, in the 10th book, which deals with national and international arbitration. And basically everything can be found there. And like in France, there is some case law, maybe not as detailed as in France, but there is case law of the German Supreme Court, Bundesgerichtshof, which should be taken into account when asking for recognition and enforcement.
Thank you very much, Axel. Stelios Gregoriou for Greece. Stelios is a Greek lawyer and an LLM graduate from the LSE, London School of Economics. Currently, he's based in Athens and he's very active in arbitration. Stelios is a fellow of the Chartered Institute of Arbitrators. Stelios, over to you. Thanks.
Dear colleagues, it's my privilege to be here with you today. The Greek law incorporates the recognition and enforcement provisions of the New York Convention by three distinct legal instruments. First of all, very early in 1961, by a legislative decree, the New York Convention was ratified by the Greek legislation. After that, the Greek Code of Civil Procedure, articles 903 up to 906 that I have referred to the table that Jacopo has prepared for us, makes a very extensive and analytical presentation of the requirements so as an arbitral award to become recognized and enforceable in Greece. And also the new Greek international arbitration law in articles 44 and mainly in 45 refers once again to the New York Convention, just to highlight the importance of this instrument for the recognition and enforcement. Last but not least, there is a corpus of 17 bilateral treaties for judicial assistance.
17?
Sorry?
How many?
17.
17.
17. For instance, with countries like ex-USSR, ex-Yugoslavia, ex-Czechoslovakia, but also there is a bilateral judicial assistance treaty with Germany. Of course, there is a sort of problem concerning the hierarchy between New York Convention and those bilateral treaties, but obviously New York Convention supersedes in case there is no lex specialis included in those 17 bilateral treaties. So this is roughly the corpus of the Greek legislation. Thank you.
Thank you, Stelios. Now going ahead, we are going according to alphabetical order of the countries. It's time for Lithuania and Solveiga Vilčinskaitė. Hi, Solveiga. Solveiga is a member of the Institute, is a partner at TGS Baltic, an international business law firm. And Solveiga specializes in complex state liability issues, international investment law, and commercial disputes. Solveiga.
Thank you very much for giving me opportunity to speak today on such an interesting and relevant topic, actually, from international law perspective and comparative view. So from the legal point of Lithuanian law, of course, we are not like German and French. Technically speaking, we have not a general part of civil procedure devoted for those questions, but we have specific legal regulation, the law on commercial arbitration, which has in its own specific article devoted for recognition and enforcement of foreign arbitral awards. And actually, it is transporting more or less the main provisions of New York Conventions here. So this is it. Of course, there are some subsidiary, let's say, provisions included in Civil Procedure Code for general procedure, how it goes, this enforcement procedure, what is the time limit and other things. But more or less, there is a specific regulation and everything is included in general to one article. Also, we cannot say that we have a considerable amount of court decision or court practice on this issue because we ratified New York Convention when we got independence. It was in 1995, and the specific legal act has been adopted in 1996. But nevertheless, we have important court precedents, which I mentioned, I think, a bit later. But in general, I can say what we follow the international practice of New York Convention of other countries, and this is it.
I see. Thank you, Solveiga. It's time for Italy. Giovanni Profazio is a fellow of the Institute. He's a lawyer and chartered accountant and official auditor with office in London and Rome, expert in national and international arbitration. Giovanni, how your national law regulates recognition enforcement of foreign arbitral awards.
Well, thank you for your kind introduction and a good welcome to our audience. I will be very, very fast. International arbitration is dealt by the Code of Civil Procedure, and especially in particularly Article 839 and 840 for our audience. That's why, because we think that as every civil law country's arbitration is an inextricable part of the civil procedure, and it's correlated with the civil procedure. And any kind of amendments may be done just by amending that articles. However, I must tell you that on the other hand, there are few law cases, because as we'll see in the next coming part of this webinar, the proceedings is very much formal, so there is no room for interpretation by the court, which is good, just because it gives certainty to the applicant. So there is no special enactment for international arbitration. There is no special law, as it is in common law countries.
Okay, Giovanni, that's it. Okay, thank you. Anton Azoskov, Professor Anton Azoskov from for the Russian perspective. And Anton is a professor of law and a member of the governing bodies of the Hong Kong International Arbitration Center, of the DIS, German Arbitration Institute, and several other Russian arbitral institutions. Anton, which is the situation in your country? Thanks.
Jacopo, thank you. First of all, thanks a lot for inviting to these interesting events. I think the idea of such series of webinars devoted to the most important issues of international commercial arbitration is a great idea, and I'm proud to be a part of this.
Thank you.
In Russia, the regulation is different depending on whether we talk about grounds for non-recognition or non-enforcement or procedure. So the grounds for non-recognition and non-enforcement, they are regulated by the New York Convention and by a special law on international commercial arbitration. This special law mainly follows the UNCITRAL model law on international commercial arbitration, and even numbering of articles is the same as in UNCITRAL model law. As for the procedure, in Russia, there are two main branches of state courts, namely commercial courts for commercial disputes and so-called courts of general jurisdiction, where ordinary disputes with individuals not connected with commercial activities are heard. So the applicable procedure depends on whether you have a commercial dispute, then it is regulated by the Commercial Procedure Code. But if you have a dispute with an individual not connected with a commercial dispute, another code, Civil Procedure Code, will be applied. That's the
Thank
general
you,
framework.
Anton. So may I ask, does that mean that you can have awards, international awards, which are not considered as commercial awards?
Yes, I can imagine this. So, well,
They are
it's
not
an
necessarily
interesting.
commercial. Can be also like
Yes, yeah, you may have an arbitration which is not connected with some business
yeah.
between, for example, between two individuals. And if they
Okay.
have an arbitration clause and for an award, it's also enforceable in Russia, but under a different code and in separate branch of Russian state codes.
I see. Thank you very much, Anton. Now, the alphabetical order of the countries leads us to Spain, and Sonsoles Moreno will tell us how it works in Spain. And Sonsoles is a Spanish lawyer, and she deals with international arbitration. Sonsoles.
Thank you so much for this opportunity, and good morning for all the audience. The first thing to say, Nazare apologize, our president in Iberian chapter, apologize for not being here, but she has another important matter to attend to. And about arbitration here in Spain, is our law governing arbitration, which regulate and apply the principle of the New York Convention of the Recognition and Enforcement of Foreign Arbitral Awards. The decision confirming or rejecting recognition can be challenged, but the avenues and requirements for doing so vary. Applicable law. Our law is in Spain, we have a system, a money system, which is based on law 16/2003 of December 23rd. Can you see in the comparative table? On arbitration, appeals are limited to extraordinary remedies. The decision confirming or rejecting recognition may be challenged. An appeal against the decision denying recognition is not admissible through ordinary remedies. Only is possible to file a cassation appeal for procedural infringement before the Spanish Supreme Court, our famous Supreme Court now, because there are many political subjects there. Is certain and the requirements are met about relative to the fundamental rights above all. It's okay.
Thank you very much, Sonsoles. And now we go ahead to the second question, which is how your national law regulates recognition enforcement of foreign arbitral awards. This time we can go a little bit in depth of the different legal sources. And as it was mentioned, we have prepared comparative table where it is reported with an informal translation in English, which is the statutory law in these different countries. So again, we start from France. Alexandre, can you please explain a little bit the details of these provisions?
Yeah, well, the set of provisions is basically the same. You have common corpus between domestic arbitration and international arbitration, which therefore applies to both situations. But there are some articles which specifically apply to international arbitration. I would focus in particular to our Article 1520 of the code, which sets the main conditions upon which the main cases upon which the international arbitration award can be set aside by the court, which are basically 5. I will rapidly quote them because they are important. So the first one is when the arbitral tribunal wrongly declared itself competent or incompetent. The reason being that the arbitral tribunal has priority to decide on its competence, whether it has jurisdiction. That means that the control of the court is after the arbitration award has been rendered. So in situations where the arbitral tribunal wrongly declares itself competent or incompetent. The second case is when the arbitral tribunal was irregularly constituted. That would mean a situation when the appointment of the arbitrators was not fully consistent with the arbitration clause, for instance, or the questions of independence of an arbitrator. The third case is when the arbitral tribunal ruled without complying with the mandate conferred by the parties. So that would typically be a case where the tribunal overstepped the questions and the orders, or overstep the mission that the parties conveyed to the arbitral tribunal. The fourth case is violation of contradictory debates. That's the case where, for instance, the arbitral tribunal would have decided on the question which was not submitted by the parties and not submitted to the parties to debate on. And the fifth case, which is quite important, we can discuss that later on, is in the situation where the recognition or enforcement of the award would be contrary to international public policy. And that's an important part that we will discuss later on with the next questions.
Yeah, you're right, Alexandre. We discuss further this aspect later, and probably we will also address something that I would raise now. I don't see a reference here to arbitrability of the subject matter, and I think we will.
Just to interrupt you on that, arbitrability is typically in the first condition. So that would be typically a case where the arbitral tribunal would declare itself competent, whereas it is not, because the matter at stake is not, in fact, arbitrable.
Okay, we'll get back to that. Okay, thank you, Alexandre. Germany, Axel, could you please explain how your national law regulates in detail the recognition and enforcement?
Yes, of course, Jacopo. As I said, the German law on arbitration as a whole is found in the 10th book of the Civil Procedure Code, and Germany has made very, very few reservations, only very minor reservations when it adopted the UN model law. I would dare say that Germany is a true model law jurisdiction. As I said, there are very few differences which do not play a substantial role in this context. The law, though, differentiates between domestic arbitral awards and foreign arbitral awards. This is one of the few differences the law makes between domestic and international arbitration. And the rules can be found in section 1060 for domestic arbitral awards and in section 1061 of the Civil Procedure Code for foreign arbitral awards. And as you may see on the screen, section 1061, paragraph 1, very clearly refers the rules for recognition and enforcement of foreign arbitral awards to the UN Convention. So it states that recognition and enforcement of foreign arbitral awards is governed by the Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 10 June 58, which is the New York Convention. And basically that's it. I mean, it does not endeavor to make any to design any differences in the scope of the process of recognition and enforcement. It's also noteworthy that in the 1998 reform of our arbitration law, the legislator has changed the competence, first instance competence of the courts for recognition and enforcement matters. It used to be at the lower district courts, and with the idea of making use of better wisdom and more experience of judges, the legislator in 1998 decided to give the competence to hear enforcement and recognition cases in first instance by the higher regional courts, Oberlandesgerichte, and they have specialized departments for arbitration, and usually the quality of the court decisions is quite okay. We have courts with more experience and courts with less experience. I would say the best experienced higher regional courts for arbitration can be found in Frankfurt, because Frankfurt is the seat of many arbitrations in Germany. Also Munich, there it's the highest Bavarian district regional court, Bayerisches Oberste Landesgericht, but also in other places like Stuttgart, Karlsruhe, Hamburg, and probably also Cologne. And what should also be noted is that we have a reform project for arbitration law, which was discontinued now because our parliament has been dissolved, because we will have snap elections in less than 4 weeks from today. But I am very certain that this project will be restarted after the new parliament has been constituted. The project was very advanced, and in the draft law, in the draft modifications, the arbitration community was involved, DIS was involved, the German Arbitration Institute, and the differences will reflect new techniques in arbitration, like having oral hearings by video, use of other languages, and most probably in terms of the competent courts, the states of the Federal Republic will be allowed to confer jurisdiction of international matters to the so-called commercial courts. We have already some commercial courts able to handle matters in English. And there will also be, or there is already, an appeal I will come back to in the context of the next question.
Yeah, thank you very much, Axel. Yes, I know that in Germany they are very active with the commercial courts, let's say, international commercial courts. I wonder if this is the right time to ask you this question. Is there going to be a specific competence of these commercial courts in terms of applications for the recognition and enforcement of foreign awards, or it is still like it is, for example, in my country, the local court of appeal, without mention on the specific commercial competence, let's say?
Yeah, at the moment there is no competence for the commercial courts to hear enforcement, recognition and enforcement cases. The situation of the commercial courts is not uniform in Germany yet. Baden-Württemberg was one of the first states in the Federal Republic to have a commercial court, and they sort of usurpated the domain name. If you enter commercialcourt.de, you will find the Baden-Württemberg commercial court, or also commercial-court leads you to the Baden-Württemberg court, but other states have commercial courts too. And since this part of jurisdiction to some extent in Germany is assigned to the states, the law project will allow the states to confer jurisdiction of these matters to the commercial court, provided that the law is made. And as I said, it has been discontinued at the moment due to the dissolution of our parliament. But I expect that there will be more rules regarding the involvement of commercial courts in recognition and enforcement proceedings.
That is probably the future.
Yes, but not now, not at the moment.
Not now, yeah, in the future, Okay, thank you very much, Axel. And now, Stelios, could you please lead us through the
Yes,
Greek
the Greek law. I would go to the Article 903 of the Code of Civil Procedure, which is the cornerstone of the procedure of recognition and enforcement.
Sorry, Stelios, which article? Sorry,
Article 903 of the Greek Code of Civil Procedure. It's up there. Just yeah. Actually, this article is the incorporation of the positive requirements of Article 4 of the New York Convention. It doesn't differ at all, I would say, but just clarifies some aspects from a Greek standpoint. So there are actually 6 requirements. First of all, the arbitration agreement must be valid pursuant to the lex arbitri. That means that must be delivered by a lawfully constituted arbitral tribunal. Secondly, the arbitral award must be consistent with the context of the arbitrability that is valid in Greece. So in some aspects, in some countries, there are cases that they have arbitrability, but they are not acceptable according to the Greek law. For instance, labor cases. So in that case, even if there is an arbitral award, for instance, in a labor case, there cannot be enforceability. So arbitrability is number 2. Third, this decision must be res judicata, in the sense that there is no pending any remedy, appeal or cassation appeal or recourse, or any other remedy against the arbitral award. Fourth, it is very important, and it is one of the most important points that Greek courts insist about the res judicata of an arbitral award, whether the right of defense has been exercised properly. For instance, very recently we had a CETAC case, and there were some inconsistencies about whether the Greek party was summoned in a proper way before the CETAC, and the court did not accept the recognition of the CETAC award. Very important issue, the right of defense. Fifth, this arbitral award must not be contrary to a Greek judgment of a civil litigation court, of an ordinary court, let's say. And sixth, which is one of the most controversial points all over the world, not only Greece, it is the issues of the public policy and good morals, which, well, it's so extensive that I cannot get in that. I would go now to Article 45 to present 2 novelties of the Greek legislation, and I close here. If you allow me, we can go to Article 45. Yes, please.
Sure.
Article 45 is the Greek international arbitration law, which goes, which is actually the ancestral version, the last ancestral version. supposedly Greece has no, it has incorporated, it has ratified New York Convention as a corpus, as such. Apart from two reservations that have ceased to have any effectiveness right now. The one is the mutuality, because the New York Convention has become a universal instrument. And secondly, the commerciality. There is a reservation because in Greece and some continental countries, there is a distinction with the Anglo-Saxon countries because we accept distinction between the commercial and civil cases, whereas in the Anglo-Saxon countries, there is no such a distinction. So the two novelties, let's say, probably they don't have any practical value between us. First of all, there is no obligation to the party that is the creditor, the award creditor. It has no obligation to adduce to the court the arbitral agreement. Once it has to present and adduce the arbitral award and the authenticated copy of it, or the authenticated copy of it. But on the other hand, it has no obligation to adduce the arbitral agreement or an authenticated copy of it, which is the obligation deriving from the New York Convention. Well, this has been abolished according to the new Greek law, as you can see in Article 45. Probably it has no practical value. It is a minor facilitation to the parties. And secondly, which is most important, is that the Greek courts apply the New York Convention by all means, even the originating country has not ratified the New York Convention. Somebody would say that this is a revolution, but taking into account that a few countries are still out of the New York Convention, probably it has no practical value because the countries are not, I don't underestimate, but are minor in the world market. And but some countries might think about that as a potential way to attract cases, cross-border disputes, etc. And secondly, which is equally important, but probably practically not important, is that the recognition of the arbitral awards in Greece can become, even if the dispute is not commercial. As we said before, in Anglo-Saxon countries, there is no distinction between commercial or non-commercial. And now the Greek code probably tries to attract some cases that they are non-commercial, which is a wise reflection of the legislator, but probably with no practical value. So with those small novelties, Greece is trying to become attractive and to simplify the enforcement process. Thank you.
Thank you very much, Stelios. And yes, indeed, I think there is a reservation in the New York Convention which deals with commercial or non-commercial issues. Yeah, so this is a topic. Thank you. Now, Solveiga will explain us better how the Lithuanian law works on recognition enforcement of foreign agreements. Solveiga.
Thank you very much. So, as I told initially, we have specific regulation, law on commercial arbitration, and one article in General 51, which is devoted to recognition and enforcement of foreign arbitral awards. Actually, legal regulation is not long, and in general, it is understandable. The first paragraph is devoted to the general provision, which says directly that Lithuanian law is fully consistent with New York Convention. The Article 51, paragraph 1 states that arbitral award, foreign arbitral award can be enforced and recognized under the rules of New York Convention. And this is it. Second and third paragraph are procedural. They refer where to apply to the Court of Appeal and where to submit an appeal for the decision of the Court of Appeal, the Supreme Court. And in general, this is it. So this is our legal regulation. It is really very pro-arbitral, let's say. That was the political position. And in general, if you take our court practice, which is not very solid, let's say, but we have examples on that, it is really also pro-enforcement and pro-arbitral and very liberal, following in general good international practice. And our, for example, Supreme Court usually cites this legal doctrine, international legal doctrine for arbitral awards on those issues, taking example from Germany, France, and whatever. So in general, what we can say what it is more or less consistent with the let's say, well-recognized international practice. Of course, we can say what usually, Lithuanian usually say, but devil hides in details, and we also always have to take into account certain circumstances and certain cases. But even if I can say that there were some fluctuations, debates on some court decisions in Lithuania, but now recently I can say that usually the presumption that arbitral award is enforceable is a rule which is strictly followed by our Lithuanian courts. All legal grounds for non-enforcement, all the list is exhaustive. It is interpreted very narrowly in general. And it is widely recognized that even a mistake on law and facts in arbitral award is not a ground for non-enforcement. It has to be manifest mistake, let's say. The courts are not allowed to review the arbitral award de novo, but it's recognized. Even the public order is understood not like completely national legal order, it's understood like international legal order. So in general, it's rather easy to seek for enforcement and recognition of arbitral award. Of course, there was some kind of debate and a bit difference in practice, for example, concerning the position whether the fact that, for example, arbitral award is annulled in the lex arbitri state, whether it is a ground for non-enforcement. So we have one example from previous legal practice where the court told that you have to respect this court decision of non-enforcement. But now the position, if you take a look to our practice, is that in general, the fact itself is not sufficient. Our courts are allowed to enforce arbitral awards, even though in the place of arbitration it is annulled. Or it is also not obliged even to suspend the proceeding if there is a still pending procedure of annulment in lex arbitri place. So there are, I can say, only few examples where certain arbitral awards were not enforced. So recently, it's always a question concerning sanctions. So it's really very political sensitive question. So I think in each country it's an issue. And let's say one example interesting was on punitive damages, which was recognized as against public policy in Lithuania. And in general, this is it. So we can say that we are arbitral friendly state, and all is followed by New York Convention. So this is it.
Thank you, Solveiga. Now, before going ahead, we have a question on Greek law, which I think has already been answered. They ask, Essam Youssef asks, if you don't mind, could you tell more about the arbitrability and public policy in Greek laws? The topic today is on recognition enforcement. So I guess the reference is to arbitrability and public policy in the stage of recognition enforcement. But Stelios, I would say, already addressed this point, because we have been talking about arbitrability, which must be a filter, a requirement before.
Number two. Sub-paragraph 2.
Number 2, yes, this was the article, and number 2 deals with arbitrability. Okay, that's the exact reference.
And public policy number 6.
Number 6. Yeah, so this reflects, of course, the principles of the New York Convention, and I would say that that is pretty clear. Okay, so I think we can go ahead with Italy. Giovanni Profazio, how about Italy?
Thank you, Jacopo. Well, Italian national law, I would say, is fully consistent with the New York Convention. As a matter of law, Article 839 reproduces to the letter the provision of New York Convention, Article 5. The paradigm being the agreement and the award with the limit of arbitrability and public policy. It's just as the same as Article 5 of the New York Convention. However, as far as law is concerned, I would say that this is a second degree rule, because the first degree rule would be the convention itself, since we ratified entirely the New York Convention, which would mean that in case of discrepancies, and in case of position between the two, the New York Convention would prevail. However, it's just a problem of doctrine, because in practice, there is no huge difference. There is no difference whatsoever between the two provisions. Having said that, I would focus our audience to the fact that we are very proactive arbitration, international commercial arbitration stance. Because the proceeding itself is super fast, which is very uncommon for Italy. The proceeding to recognize the international awards. In fact, the proceedings would be not an adversarial proceedings, but in absentia proceedings. I mean, a judgment in default. A judgment in default. These proceedings, you have just to file the copy of the award, the copy of the arbitration clause or arbitration agreement, but both of them needs to be certified. And this is the problem, because to get a certified copy of both, you need to address anyway the tribunal. However, as an advice of best practice, I would say that since you are not required to have the certified copy from the same tribunal where you filed the recognition, you can go everywhere in Italy, everywhere. So I strongly suggest our audience, if they bumped into Italian proceedings, to go to have a certified copy, even from a local district tribunal, and then produces this to the competent Court of Appeal. Why I'm saying Court of Appeal? Because the proceedings needs to be brought not at the tribunal of first instance, but the second instance, before the Court of Appeal. And technically would be the Court of Appeal where the defendant has got his domiciled, or if it hasn't any domicile in Italy, the Court of Appeal of Rome would be competent. So, in a way, the 90, I would say also 95% of the cases are brought before the Italian, the Roman Court of Appeal, because since we are dealing with international arbitration, chances are that nor the plaintiff nor the defendant has got a registered domicile in Italy. I would say also that since it's very formal, the proceedings would define and would address an immediate enforceability of the award. And that is, to me, very important, because as Italian lawyer, I'm very accustomed to have a very long-lasting proceedings. Instead, this is very fast. And we are, in a way, we are proud that we can help the international community to get at least a very fast judgment in Italy. Thank you.
Thank you, Giovanni. Now it's Russia's turn, and Anton, over to you. Thank you.
Yeah, thank you. I will start with Article 36 of the Law on International Commercial Arbitration. Yeah, it's a little bit down. You may see that, yeah, Article 36, you may see that this is mainly a repetition of the same article from the ancestral model law, which in turn is based on Article 5 of the New York Convention. So formally, if you look at the legislative text, you will see, well, no differences from internationally recognized standards. But Solveiga was correct, saying that devil is in details, and this is also the case with Russia. I will mention 3 interesting issues regarding which there may be doubts whether these approaches of Russian case law correspond to the New York Convention. So the first problem, very well known to any lawyer dealing with enforcement in Russia, is the broad interpretation of public policy. So sometimes the understanding of public policy comes close to reconsidering the case on its merits, which is, of course, not in compliance with the internationally recognized standards. The second interesting feature is the recent amendments regarding sanctions. If we go a little bit up to the, yeah, here it is. So this is Article 248.2. This is a part of the so-called infamous Lugovoy law, which has its name after a well-known Russian spy who tried to poison people in England. Now he is a part of the Russian parliament, and he introduced this bill dealing with the influence of sanctions. And a part of this bill is that Russian courts now has the right to issue anti-suit and anti-arbitration injunctions. So there may be, and this instrument currently is used quite frequently by Russian companies. So there is an opportunity that a Russian company will go to Russian courts if it obtains such an anti-arbitration injunction, which is not complied with by the parties. So still, foreign tribunal will issue its awards. The recognition and enforcement of such an award will be refused in Russia based on this article, I think in conjunction with public policy clause. And the last issue, there is an interesting case law saying that in order to enforce a foreign award in Russia, the applicant must demonstrate that the respondent has either its place of residence or branch, or at least some assets in Russia. If the applicants cannot demonstrate this, Russian courts will say that Russia does not have so-called effective jurisdiction, and this case should not be heard in Russia, and the application will be denied. So again, there might be doubts whether this is in compliance with the New York Convention. And just one last point about the procedure. If we can go a little bit up here, Jacopo, to Article 245.1. 245.1. Okay, so it's interesting that we have a different procedure for awards demanding enforcement. So, for example, payments of some monetary awards, and it's a different procedure for awards which demand only recognition, but there is no need for enforcement. So, for example, this is a declarative award declaring that certain transaction is invalid. So, no need to pay any money under this award or to hand over any assets. Here it's interesting that Russian legislature, it says that the relevant awards will be recognized automatically, so there is no need to make an application to the courts. And this is the burden of the respondent. If it wants to block recognition in Russia, the respondent must raise before the Russian courts its protest objections against recognition of such an award. I think this is quite interesting, peculiar procedure. I don't know if there are any similarities in other countries we are discussing now. So that's it. I don't know. Yeah, Jacopo probably has troubles with his connection. Don't know if we can still move on.
It seems Jacopo is not there anymore, so he must have been, he has disappeared, so he will certainly come back. So maybe we can move to the next. I think it's you for Sonsoles for Spain, no?
Yes, it's my time.
Okay,
Yes.
good. So let's.
I'm going to be very short. I'm going to be very short because we don't have time. Okay, I have included difference between the New York Convention and local arbitration law by points. First point, or 1 point, scope of application in New York Convention refers to foreign or not domestic hours. In our local law in Spain, applies to both domestic and international hours, with more detailed provision of the arbitration process and the annulment of hours. About the second point, about the annulment of hours, does not directly regulate the annulment of hours, and in Spain, annulment of hours Spain established its own criteria for requesting and granting the annulment of arbitral hours, like tribunal was improperly constituted, tribunal manifestly exceeded its power, for example. Third point, or 3 points. 3 points. The concept of public policy in New York Convention broadly interpreted, but in Spain interpreted with regard to situation and conditions of the Spain relative our local law. And 4 point, autonomy of the parties broadly regulate, allowing freedom and choice as long as it does not contradict the public policy on the enforcement state. And in our local law, more explicitly regulate in the respective local laws. The 5 point, recognition and 40 hours in New York Convention may only be denied for limit reasons, and in Spain may be denied for limit reasons, but for example, in Spain, additional review is allowed if the hour affects Spanish public policy. The most important difference for me is the automatic recognition exequatur, because in New York Convention, the the hours, the foreign hours are automatically recognized, but in Spain is necessary a special procedure called exequatur process. Conclusion: local law aims to comply with the principle of the New York Conventions while adapting them to the specific characteristics and legal frameworks in Spain, Spain. Okay.
Okay, I'm back. I'm sorry I lost the internet connection. Thank you, Sotsoles, for having gone ahead. That was correct. So I think we have finished the answers to question number 2. And now we can switch to question number 3. Is the decision that upholds or dismisses the recognition subject to challenge, and which is the body to be approached if there is the right to a challenge? We start again from Alexandre.
Yes, thank you, Jacopo. I'm glad that you're back. So yes, well, I was not very complete for the second question. Maybe I will complete on that matter, which is very important. So in France, for international arbitration awards, the Paris court has jurisdiction exclusively to decide on that. So that means when you have an international award, it's quite fast. You bring an ex parte request to the first instance judge, which is the Judicial Court of Paris. And in, let's say, 15 days to 3 weeks, you get an enforcement order from the first instance judge. And in the control of the judge is very formalistic, so it's very fast and very formalistic. Thereafter, this order must be notified to the other party for the purpose of the enforcement, and the party has a time limit to file an appeal against the ex parte order, the enforcement ex parte order, and this appeal comes right to the Court of Appeal of Paris. So that means, and that's a very important point to understand, that means that the Court of Paris has exclusivity to decide on arbitral awards, international arbitration awards. And that also means that we have a strong and continuous corpus of case law in international arbitration, which is easily understandable, and you have a line of case law from the Court of Appeal of Paris, and of course after that the Supreme Court, the Court de Cassation. Where we are quite lucky in France for that, because for a few years now we have a specialized chamber at the Court of Appeal, which is the International Chamber, which is specialized in international, commercial international cases, private international law, and international arbitration. So we have judges that are very specialized in international arbitration and very easily understand the applicable text and the case law.
And they work in English.
And they work in part in English. So at the beginning of the process,
oral hearings probably in English.
That's right. So basically, at the beginning of the process, they ask to the lawyers whether they accept to file documents in English if they want. And in some cases, you can even have witnesses, and that's part of that I will explain in a minute. But you can have witnesses in English, heard in English. So you are entitled to have translation, but that's not compulsory. So that's very useful for our processes. So I mentioned that you may have witnesses, and that's part of the point that we may come back to later on. But the reason for that is that there is no review of the arbitration of the award. That's very important. That's in line with the New York Convention. But in some cases, you have the possibility to reopen some parts of the debates. and especially on two aspects. If you go in line with the last few years regarding two aspects. The first one, which I quoted, is the question of independence and impartiality of the arbitrators. So this is a point where the Court of Appeal can go quite in depth into checking these two aspects. And the most important is public order. And the evolution of public order in French law is interesting because there was a very narrow interpretation of public order until 2017 and 2022, where you have one important case law, which is the Bélocon versus Kyrgyzstan case, where the Court of Appeal considered that you have specific situations where, for instance, corruption is at stake or money laundering, where the parties would be entitled to reopen the debates in front of the Court of Appeal, including file new documents, including file new witnesses that have not been presented to the arbitral tribunal, in situations where public order justifies reopening the debates on these points. And you can even have situations where the parties have not debated this in front of the arbitral tribunal, but you have an issue of a strong issue of public order in front of which comes in front of the Court of Appeal of Paris. That's why, in fact, you may have witnesses coming for the first time in front of the Court of Appeal. So that's basically the situation. We can, if you would like later on, rediscuss on this important question of public order, but that's the main point. Another thing that I would like to highlight is that in spite of the fact that you have this appeal process, it goes quite rapidly because, as I mentioned, the first instance court issues an enforcement order which goes very rapidly, and the appeal of this order is not suspensive. So that means that you can enforce the arbitration awards, notwithstanding the fact that you have appealed or there is an appeal pending in front of the Court of Appeal of Paris. That can be stopped, but it's very difficult to stop, in fact, the enforcement of an arbitration award.
Thank you, Alexandre. Thank you, Alexandre. Axel, for Germany, is a decision that upholds or dismisses the recognition subject to a challenge in your country?
Jacopo, yes. You have allocated 1 minute to me, so I will be brief. It is possible to appeal the decision for the party losing the first instance proceedings. And it goes to the Supreme Court, Bundesgerichtshof. There is a specialized chamber there, and they are dealing with it. There are no special provisions as to the scope of the review. It follows the New York Convention. The probably most important case is the party losing the first instance proceedings, invoking infringement of public policy, and within the infringement of public policy, the infringement of the right to be heard is the most prominent one. It happens quite often, but the jurisdiction of the Supreme Court is rather strict. It is not sufficient that there is an infringement of the right to be heard. As such, the infringement of the right to be heard under the case law of the Supreme Court must have a substantial relevance for the final decision. Only then the first instance decision can be revoked and the annulment of the award be set aside, or the other way around, recognition and enforcement be granted. And unlike France, there is no possibility to start the enforcement of the award until the case is finally cleared by the Supreme Court.
Okay, I see. Thank you, Axel. Stelios for Greece.
Yes, Mr. President. I would like to answer to some questions from the audience. I mean, Mr. Zafar Kalawani has submitted 2 or 3 questions relevant to our discussion. The exequatur is not automatic in any jurisdiction. So we have to apply. In Greece, we have to apply, unfortunately, before the first instance court, differently from Italy, where there is an introduction of the case directly to the appeal court, which is more effective and gives more, makes the procedure more quick and costly effective. So the introduction of the case is in the first instance court of the awarded debtor, or where the assets of the award debtor are traced. This decision is challenged before the appeal court, which is on the grounds of legal and factual motions. So in that case, we have probably we have a very luxurious procedure. And then for purely legal matters, there is also the challenge of the appeal court decision before the Supreme Court. So we have a 3-tier mechanism that really makes the enforcement and the delivery of an exequatur very delayed, despite the will of the legislator of the new arbitration law in Greece. Because this is important to underline that if you might have the best will, but if your code of civil procedure lets you down, then it doesn't work. That's important.
Yeah, good to know. Yes. Okay, that's the need for local lawyers that Redfern and Hunter mentioned.
Exactly.
So for Lithuania, again, Solveiga.
Yes, thank you. Thank you very much. So under Article 51.3, paragraph 3, it is established that the application for the enforcement and recognition shall be submitted to the Court of Appeal, who is the first and the main instance for this procedure. The interesting point is that it comes into force the same day it is adopted. It is heard by 3 judges panel in written procedure, and usually it's not usual to have oral procedure. You always may ask under general rules of civil procedure code, but usually it is heard in written procedure. And afterwards, you have 30 days for the appeal to cassation, and under the grounds established by General Civil Procedure Code, and it means that the cassation stage or appeal stage for the enforcement procedure are exceptional, but more or less in Lithuania for the arbitral awards, our practice is rather liberal. And if you can prove that the Court of Appeal deviated manifestly from the legal practice or something like that, you, in general, the Cassation Court, the Supreme Court, it accepts application. But you have to keep in mind that it's only 30 days because usual term for cassation is 3 months.
Okay. Okay. Again, need for local lawyers.
Yeah, need for local lawyers a bit to know
Something
peculiarities. Yeah.
To be borne in mind.
Yeah.
Thank you. Is that it? So
Yeah.
you finished? Okay. Giovanni, which is the situation in Italy?
Yes. Well, in Italy, as I told you before, the proceedings is super fast. So there is room for an opposition. However, is not an appeal because the proceedings is already before the Court of Appeal. So the opposition will be internal. And of course, this opposition will end with a judgment, and any kind of judgment can be challenged before the Supreme Court. but this is not a problem because the Supreme Court would only be scrutinizing the proceedings, not the law. I mean, not the merits. Well, as far as the opposition is concerned, is fully consistent. The grounds of opposition, of course, are fully consistent with the New York Convention. Article 840, as a matter of law, provides as a grounds for refusing and set aside the application for recognition, the same as the New York Conventions, being the incapacity of the parties, the violation of the rights of defense, and when the arbitration doesn't fall within the scope of the arbitration agreement, which doesn't mean arbitrability, is something different, and error in procedendo, and when the award is not binding. So in a way, the provision is, the grounds of the provision are as the same as the one provided for the New York Convention. However, I would focus on two important aspects, if I have some very few seconds, Jacopo, if you allow me.
Yeah, please go ahead.
Because it's very important. First of all, the said article provides for severability. That's very important because if there are some parts of the award which cannot be recognized and that needs to be set aside, it doesn't mean that the entire award will be set aside. It does depend on the content of the award itself. So chances are that part of the award, part of the remedies will be set aside and part declared enforceable. This is very important because I think everybody of us know that an arbitration, sometimes an award contains lots of remedies, such as penalties, interest that can be set aside depending on the place of enforceability, the place of enforcement, no? Because it does depends on the local law. And this is, as said before, a measure which implements and is a stance in for the international recognition of the international award. And besides, I would say that there is a recent judgment of the Supreme Court, which is really, really relevant, according to which the problem of arbitrability and public policy, in order to be a grounds for setting aside of the recognition, needs to be recognized not from the reasoning part of the word, but just from the dispositive part of the word, which means that the judge has not to go all through the word to assess whether or not it was arbitrable or infringed the public policy, Italian public policy. But he needs to relegate his scrutiny just to this positive party. This is, of course, also important because in a way is an underwriting of the formal proceedings, and once again is a pro, is something in favor to the international recognition of the international awards.
Okay, which
I can put for the audience, I can put this last judgment.
Thank you. It would be welcome. Which means, Giovanni, correct me if I'm wrong, that
Yeah.
in the panel there is a kind of dissenting arbitrator. He or she should be able to put reasons in this positive part to
Exactly.
to let the judge understand better
Exactly.
the definition of arbitrability. Okay. Okay.
We in Italy, we say, I think everybody can understand, inutiliter data. His dissenting opinion would be inutiliter data as far as recognition is concerned.
Mm-hmm. Okay, thank you.
Welcome.
Anton.
Can I put the decision on the chat, Jacopo? For the
Yes, if you can, yes, be very welcome. Thank you. Anton, over to you for the situation in Russia concerning the challenge to dismissal or acceptance of the recognition.
Yeah, thank you. So in Russia, the applications for recognition and enforcement are made to the courts of first instance, but there are differences in respect of available appeals in comparison with ordinary commercial cases. So in ordinary cases, there are three available types of appeal. Here we will have a problem with terminology because in Russia, cassation appeal, so different from France and different from, as far as I understand, Lithuania, cassation appeal is not before the Supreme Court. So this is another level of courts similar to, I don't know, circuit courts, district courts. So in ordinary commercial cases, there are three types of appeal. So just an ordinary appeal to appellate courts, then so-called cassation appeal to circuit district courts, and finally appeal to the Supreme Court. Different from that, for cases on recognition and enforcement, only two types of appeals are possible. So the first one is directly to the cassation appeal courts, and another one to the Russian Supreme Court. So that's briefly the framework.
Thank you, Anton. And yes, we can see that we have a number of different situations in every single country. So it's very good to go through these distinctions. And Anton, you mentioned earlier when I lost the connection, anti-suit injunctions and anti-arbitration injunctions. We have a very recent decision by the UK Supreme Court on this topic. And the case is Unicredit Bank GmbH versus Ruschem Alliance LLC, which is seated in Russia. So just for the audience, I read yesterday this piece of news on anti-suit injunctions decided by the UK Supreme Court, if somebody want to have a look. Sonsoles, yes, the way to challenge a decision for dismissal of a recognition or acceptance of it.
Yes, my answer to this question about relative to Spain is yes. The first instance decision can be appealed to the provincial court, and ordinary appeal is not admissible against a decision denying recognition, but an extraordinary appeal or cassation appeal is possible before the Supreme Court. Always relative to the fundamental rights regulate in our main law, Constitution. It's okay.
Thank you. Thank you very much, Sonsoles. You've been brief, which is very convenient because it's now 11:30. Our webinar is supposed to stop at this time. I don't want to keep the speakers online if they have other commitments, but if they can, or at least those who can remain, we have a last question, but it is really the case to say last but not least, because it addresses a very important point. The question is, are there stamp duties, court fees, taxes to obtain in your country the recognition enforcement of a foreign award? So we can try to be quite brief, and it could be also useful to understand at least the size of these taxes, if any. And so if you can just quickly try to assess which is the impact of a taxation on the recognition for the award, it would be very helpful. Alexandre, again, we start from you.
Yeah, thank you. I'll be very short, in fact, because there are no stamp duties in France, especially, well, because judicial court is free. The only thing is that if you lose your case in front of the Court of Appeal in this stage of the enforcement, the appeal of the enforcement order, the other party may be awarded sums to compensate the judicial costs. And in general, in international arbitration, it is much higher than in civil proceedings in general. So it's not rare to have that the court awards damages to compensate costs up to 20, 30, and even 8. I've seen cases where the costs can go up to 80,000 euros. So that's the only risk.
That's great. Okay, I remember I read earlier a question I lost the question, unfortunately, but the question about the difference between taxation on domestic and foreign awards. If you can also address that, it would be helpful. Axel, for Germany.
Yeah, Jacopo, with pleasure. I can also be brief. Stamp duties are not known in Germany, not for any official document. It's something that happens in other countries, but we have, of course, court fees. And if you apply for recognition and enforcement of an award, you have to pay the same court fees as for any other case. And these court fees are calculated based on the amount in dispute, up to a maximum of an amount in dispute of 30 million euro. Just to give you an example, the down payment for a case of 1 million euro would amount to 23,524 euros. If you win the case and you have an opponent, the opponent will have to reimburse these costs. And the same is true for the lawyer's fees, but this is limited to an amount which can be reimbursed in a regular court case. But apart from this, I would like to indicate one point, which I think is important. In our Civil Procedure Code, there is a rule that if a party acts as claimant from outside of the European Union or not belonging to a country with which we have a bilateral or a multilateral agreement on costs for court proceedings, can ask the claimant to pay a security for cost. So if you have somebody, let's say, from Brazil or from some African country, for example, filing a claim before a German court, they have to pay security for cost for 2 instances. And this can be quite a bit of a deterrent. And there is a recent decision, I think 2023, of the German Supreme Court establishing that the same claim for a security of cost can be made when you ask for enforcement, recognition and enforcement of an international award. And I think this is completely wrong. I published a comment on this because you cannot compare a recognition and enforcement proceeding with a regular proceeding for a civil claim, because the party asking for enforcement has already undergone a procedure before an arbitration court, has already had to make advance payments for the tribunal, and has won the case. And we are only talking about recognition and enforcement, but the German Supreme Court establishes the rule once claimant, forever claimant. So you will have to pay the security for cost, and this can be very high. If the amount in dispute is, let's say, 30 million, this can easily go into several million for the security of cost. And as I said, I believe it's wrong. When the reform project was ongoing, I asked the German Federal Ministry of Law to consider changing that through the law, but it was not in the law project. And to some extent, luckily, the dissolution of our parliament has led to discontinue the law reform, and it will restart again after the new parliament has been constituted. And I will try again because I think it's completely unfair and inconsistent with the idea of the New York Convention to make recognition and enforcement of foreign arbitral awards easily available.
Yeah. Okay. Terrific, Axel. Thank you very much, and bravo for your publication and for trying again to address the law reform in the right to the right way. Thank you, Stelios.
Yes, please. In Greece, for the delivery of the recognition and the enforcement court decision, there's only some bearable, I would say, court fees, and of course the legal fees, which is free. But when the decision becomes res judicata, then it must be converted to exequatur, and in that case, there is the stamp duties, as you have mentioned, Jacopo, very reasonably. It must become an exequatur, so it must be paid at a great deal, let's say. But in Greece, it's 2.4% on the capital and interest of the claim. So to give a very clear answer, 2.4%. Thank you.
Great. Thank you. Thank you, Solveiga, for Lithuania.
Yeah, I will be brief because our legal regulation, there is no any stamp duties for such a procedure. So it's a question only for expensive for lawyers. And just interesting point, like in some other countries, but our courts are reluctant to award, even for the winning party, a most proportion of your expenses for the lawyers. This is it.
And you don't have a court fees?
No.
Well. Great. Good to know. Thank you, Solveiga. Giovanni, Italy.
Well, Jacopo.
We are not as advanced as Lithuania, I'm afraid.
Well, Jacopo, as far as Italy is concerned, I must be sincere. This is our real problem, because everybody's focused on the stamp duty, so the tax related to the proceedings. That's not enough, because, okay, the stamp duty of the proceedings, in a way, they are fixed. Okay, even though they changes from the amount required, but in a way they are fixed. The problem is that also the judgment would be taxed. So there will be a tax on the judgment itself, and that's the real problem, because the tax on the judgment is is not in a fixed way, but is the 3% of the amount. That's a real, that I think makes the difference.
Which is the same situation for the domestic
exactly
state court judgment.
Exactly, same, because it's that judgment is since it will be executed in Italy, is deemed to be a domestic judgment as the same.
Okay.
And that's our problem. And in top of it, however, I must tell you that everything is correlated to the VAT system. So if the merits of the award were contemplated already the VAT system, chances are that you don't pay the stamp duty in the percentage, but only in a fixed rate. This is the case of European cases, since within the Europe VTS system, one way or the other exists. The problem is when the award is rendered outside the UN, because all other countries out of the UN, they don't recognize VAT. So they will be obliged to pay the 3% of the amount, the amount of the award. And on top of it, there is a rather recent trend of the Italian authority, which, however, I'm challenging personally, as with my firm, which requires another stamp duty on the contract, which is the basis of the award itself.
Yeah.
So the problem would be twofold.
Was that a domestic contract or was executed?
Doesn't matter what contract is, because according to the tax authority, any contract changes the rights of the parties. So any change of the rights of the party needs to be taxed.
Okay. Okay, Giovanni.
We'll see what happens, because I changed this approach before the local authority and the tax authority. We'll see.
You let us know.
I'll let you update.
Yeah. Okay, Anton, please.
Yeah, I will be very brief. So the situation in Russia is very similar to Germany, but the difference is, as far as I understand from what Axel told us, in Germany, the import duty is so 100% in comparison with ordinary litigation in commercial cases. In Russia, it's 30% from that's applicable to ordinary commercial litigations. And then we also have ad valorem schedule depending on the amounts of claim. And last year there was a legislative reform in Russia, according to which this schedule was substantially revised, and the numbers were substantially decreased. So that's why the amount of state duty today might be quite significant, even bearing in mind that it's just 30% from the ordinary state duty. Yeah, that's it.
Thank you, Anton. And Sonsoles for Spain.
Yes, it's my favorite question because it's about money. Here, yes, in Spain there are court fees, but only for legal entities, because the natural persons are exempt from paying court fees, and the amount is 300 euros plus 0.5% of the value of the hours being enforcement, with a maximum cap of 10,000 euros. In my opinion, it's very expensive here in Spain.
Yeah, the idea of having a cap makes sense. Yeah.
Yes.
Okay, I'm afraid we're running out of time. Let me check the last questions, but they were asking for the comparative table, which will be sent to the participants. So the question is, how can we watch different webinars again? I don't know exactly, but for sure they will be displayed in the CIR platforms. So please have a look at the websites of the CIR and the European branch, because they will be shortly published.
Jacopo.
Yeah.
Can you just allow me 1 minute, just 1 minute?
Yeah, go ahead.
Because I just spotted an interesting question from our audience, which is how about those countries which has not recognized, has not ratified the New York Convention? Because of course we have all our countries belongs to those one.
I'm sorry, I don't have that question because I think I lost it earlier.
Okay, no problem. I think
you can go ahead if you want to give a brief answer.
The answer is very fast. It doesn't matter. It doesn't matter. First of all, because there are very, very few. The country which has not recognized the New York Convention are very, very few. I think 6 or 7 all over the world, not more. However, if they don't, as far as Italy is concerned, but also all over the world, if they don't allow, if the plaintiff cannot rely on the New York Convention, it simply rely on the domestic provision. That's it.
Yeah. The bilateral treaties.
Bilateral.
Can I say something here?
Yeah.
Article 45, I referred before, the Greek Commercial Arbitration Code, doesn't take into account this the lack of accession of some countries. So those 6 to 7, I don't know exactly how many they are. So with this provision, you can surmount this problem. This is the answer from a Greek standpoint.
Okay.
The same like Italy. I mean.
Yeah.
We are both speculating about the real signatories of the New York Convention. I know.
6 countries, it's important.
6, 7, I don't remember, to be honest.
Stelios, if you may, I read a last question which is addressed to you. A question to the Greek speaker, Mr. Gregorio. You referred to the 17 conventions, including one with Russia. Please, can you confirm that they concern the issues of enforcement of arbitral awards, because that convention concerns judicial assistance IDEST primarily in courts. So is that applicable also to arbitration in addition to courts?
Let me see what was the last
the last question, if you want to go it.
No, I mean the last phrase of this question is let me see. Sorry, just a minute.
The question is from Dmitry Vlasov. Is the very last? No, the before the last.
I'm not ready to answer, but it is a judicial assistance bilateral agreement between ex-USSR countries. So that means that even today, because it was not terminated by any country, covers all the CIS, including Russia, Belarus, Ukraine, yes, including Ukraine. Though with Ukraine, Greece has a separate agreement in 1994, not during this period. So I cannot say that it covers specifically enforcement, but I'm rather close to say that yes, that judicial assistance includes enforcement, and it cannot be excluded, because otherwise it would not be judicial assistance, because this is the most crucial part of a civil cooperation between countries.
Okay, thank you. I see another very broad question, but I'm afraid we have to stop here. So first of all, let me thank very much the speakers who have been really great in illustrating very clearly the situation in their respective countries. I'm very pleased that you have participated, and I also want to thank the participants who participated actively and with interesting questions. So I think we can close the webinar here. And again, thank you very much to all of you, and see you soon.
Thank you. Bye-bye.
Thank you.
Thank you.
Thank
very
you.
much.
Bye-bye. Have a good
Bye.
rest
See
of the
you.
day.
Excellent.
Bye.